Thank you very much, Ángela. I am honored to moderate this fifth panel on environmental principles. And I must start by saying that since 2018 in Chile, we have a legal framework, some guidelines for the judiciary in a set of principles for sustainable development in the context of environmental law. This is a document drafted by the judiciary with the collaboration of the OAS, the Organization of American States, and the Ibero-American Legal Summit. And some of the principles included there are all of the legal principles that come from international law and in where the judiciaries and all those who have signed the protocol are encouraged to use these principles in the construction of environmental justice and environmental law in general, both the courts and the administration of the state in broader terms. Let me begin by presenting our first speaker, Professor Dinah Shelton. She is an attorney graduate of the University of California, Berkeley. She's focused on human rights. She's worked for the UN Environmental Program, the EU, the Council of Europe, and the Organization of American States. And in 2009, Dinah became the first person nominated by the United States to become a member of the Inter-American Human Rights Commission and chaired it. Dinah, you have 20 minutes available to you, and the floor is yours.
Thank you very much. It is a great pleasure to be here, the more so as during my tenure on the commission, I was not only rapporteur on the rights of indigenous peoples, but rapporteur for Chile. So thank you very much for the honor of this invitation. It's a thrill to be here. I was not able to visit Chile in person during the time I was rapporteur, so I'm glad to be here virtually and accept this invitation. I'm going to speak on environmental principles as they have evolved over the past 55 years, beginning with the call for the first environmental conference by Swedish government in 1968. Several of my comments will refer back to other presentations. I don't know why I'm not being shown there on the speaker, but it doesn't matter. Okay, so the impact of the call for the Stockholm Conference had an immediate impact, among other things, in the United States, because shortly after the call for the Stockholm Conference, the first Earth Day was celebrated in 1970. And on that day, the state of Pennsylvania held a referendum to adopt in their state constitution a right to a safe and healthy environment as a constitutional principle. And that was adopted overwhelmingly and became the first of the constitutions in the United States. There are now more than 30 that have the right to an environment in the state constitution. The federal constitution has nothing, despite it being introduced every year since 1970 at the federal level. But the fact that all the state constitutions have it has given rise to a considerable jurisprudence based on the constitutional provisions, among them the state of Louisiana, the state of Montana, the state of Hawaii, and I could go on, but I won't for time's sake. So I'll start with the Stockholm Conference, where the first principles were enunciated in 1972 when the conference was held. The declaration had a number of preparatory meetings where various issues were debated, and a draft of 17 principles was proposed. Those were fairly controversial. There was a strong North-South debate and dispute at the conference that gave rise to a renegotiation, and 21 principles were retained with 4 new ones being added and referred to the General Assembly. The declaration was adopted along with other final texts by the General Assembly. So there are 26 principles contained in the second part of the declaration. They can be grouped into themes, but several of them stand alone, and I'll focus on those that deal with environmental justice. Principle 1 in particular links human rights to environmental protection and refers to the most prominent human rights problems of 1972, condemning apartheid, colonialism, and racial discrimination. The principle reads, man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being. This convoluted syntax has given rise to several interpretations. At a minimum, Principle 1 restates existing international human rights guarantees of liberty, equality, and an adequate standard of living. The innovation lies in adding the exercise of these rights depends upon environmental conditions. And it seems to reflect an understanding that environmental degradation can impair the exercise of human rights. Read more broadly, Principle 1 initiated a widespread and ongoing movement to recognize the right to a safe and healthy environment as a new human right, something that was added to the constitutions of many countries throughout the world and to regional human rights treaties in Africa and the Americas. Many delegations thought that the declaration should begin with a general affirmation of every human being's right to a safe and wholesome environment. That was including the United States at the time. But others argued that it was implicit in the right to an adequate standard of living recognized in Article 25(1) of the Universal Declaration of Human Rights. Principles 2 to 7 constitute the heart of the declaration in setting forth the rationale for environmental protection and specific threats to the environment. They proclaim that the natural resources of the globe are not only oil and minerals, going back to the discussion at the end of the last panel, but also air, water, earth, plants, and animals, as well as representative samples of natural ecosystems. All of these should be preserved in the interest of present and future generations, bringing in the principle of intra and intergenerational equity. Renewable resources have to maintain their ability to replenish themselves, and non-renewable resources should not be wasted. The declaration emphasizes the necessity of adequate resource management and the responsibility of mankind to protect wildlife and habitats. The section concludes by calling for a halt to the production of toxic waste and other matter that cannot be absorbed by the environment, and or a prevention of marine pollution. Principle 7 is the only principle in that group that contains the language of legal obligation, stating that states shall take all possible steps to prevent marine pollution, and could reflect the negotiations then concluding to in the London Dumping Convention. The last group of principles, 21 to 26, is of particular interest in the development of environmental law. Principle 21 is generally recognized today as expressing a basic norm of customary international law. It reads, states have, in accordance with the Charter of the United Nations and the principles of international law, the sovereign right to exploit their own resources pursuant to their own environmental policies, and the responsibility to ensure that activities within their jurisdiction or control do not cause damage to the environment or of other states or areas beyond the national jurisdiction. This, of course, has particular importance today in the context of climate change. The Declaration further affirms that states should cooperate to develop international law regarding liability and compensation for victims of pollution and other damage caused outside their boundaries, Principle 22. They should define criteria and norms in environmental matters, taking into consideration the system of values in each country, particularly developing countries. Finally, states should cooperate to protect and improve the environment and ensure that international organizations play a coordinated, effective, and dynamic role in this field. Of course, the Stockholm Declaration was not adopted as a treaty and is not legally binding as such. Most of the principles in there represent an agreed statement of environmental problems identified during the conference and the then current understanding of the causes of these problems, as well as a set of relevant economic and political considerations to be taken into account in resolving them. However, several principles do have normative impact and have had an important and lasting impact on the development of international environmental law. Several delegates referred to the text as the point of origin for the development of international environmental law. In the General Assembly, representatives referred to the Declaration as an acknowledgement of new principles of behavior and responsibility to govern interstate relations, and as providing an indispensable basis for the establishment and elaboration of new codes of international law. The conference report containing the declaration was adopted on December 15th of 1972 with 112 votes and no opposition. Despite that, and because of that, and as an aftermath, several of the principles have emerged as legal norms. A large majority of the International Court of Justice declared in 1996 that the obligation of states to ensure that activities within their jurisdiction and environment respect the environment of other states, a reformulation of Principle 21, quote, is now part of the corpus of international law relating to the environment. The duty to cooperate contained in Principle 24 was called a fundamental principle of international law by the Law of the Sea Tribunal in its Provisional Measures Order of 2001. So the Stockholm Declaration provided agreed rationales for legal and political action on the problems identified, and following the Stockholm Conference, numerous initiatives were taken to conclude agreements and adopt national laws to identify the issues identified at Stockholm and the principles contained in the declaration. In particular, the UN Environment Program relied on the declaration and action plan in developing its agenda. It was based on a planetary conception of the environment and on a view of the institutional structures and world policies that was needed. It was also global in addressing all the major environmental issues of the time. And it was the major development in the evolution of environmental law until the Stockholm Conference. Up until then, most environmental law had taken a sectoral approach of first addressing inland waters, the environment, the atmosphere, outer space, wild plants and animals. And then in 1982, the General Assembly adopted the World Charter for Nature, which took a more holistic approach. And the negotiations for the Conference on the Law of the Sea resulted in UNCLOS in 1982 that has an entire part devoted entirely to the protection of the marine environment, and reaffirmed the global and regional regulations to combat marine environmental injury, including vessel source and land-based pollution, as well as pollution caused by dumping of waste and other matters. It also adopted significant new rules, in particular, the principles that states have a general obligation to protect and preserve the marine environment. During the 1980s, it became increasingly evident that a sectoral approach was insufficient to address environmental deterioration because it failed to regulate the causes or sources of harm that could affect one or more sectors. So a second approach, which aimed to regulate sources and risks of harm, became a common complement to sectoral regulation. The regulation of sources of environmental harm became much more common, and this eventually led to a common management of shared resources and an ecosystem approach. Finally, the global problems that emerged required comprehensive regional cooperation among all states, including climate change and loss of biodiversity. So new rules were included in instruments concerned with international law, including human rights instruments, humanitarian law, and economic law. In particular, the UN General Assembly proclaimed the responsibility of states for the preservation of nature in the interests of present and future generations. Later on, following Rio, we also got the UN Declaration on the Rights of Indigenous Peoples, which you heard about yesterday, and which includes an entire chapter devoted to indigenous environment. So in 1983, the General Assembly voted to create the Brundtland Commission, commonly referred to the World Commission on Environment and Development. The Brundtland report stressed the need for an integrated approach to environmental policies and projects, which, if environmentally sound, should lead to sustainable economic development in all countries. The report emphasized the need to give priority to anticipating and preventing problems. It defined sustainable development as development that meets present and future environmental and development objectives, and concluded that without equitable sharing of the costs and benefits of environmental protection, neither social justice nor sustainable development can be achieved. The Brundtland report led to the convening of the second environmental conference known as UNCED, which took place in Rio in 1992, 20 years after Stockholm. There were 172 states that were represented, making it one of the largest conferences ever held. Some 116 heads of state and government attended. Stockholm Principle 22, which called on states to cooperate to develop international environmental law and policy, was advanced by the Brundtland Commission as a precursor to the Environmental Declaration at Rio, or the Rio Declaration. So the Rio Principles, it's a short statement of 27 principles. It has a composite and compromised character due to a complex legislative history. It reaffirms and seeks to build on the Stockholm Declaration, but its central concept is sustainable development as defined in the Brundtland Report. Principle 3 declares an unambiguous and unconditional right to development. Principle 4 says that environmental protection shall constitute an integral part of the environmental process or the development process and cannot be considered in isolation from it in order to achieve sustainable development. It retains an anthropocentric approach in stating that human beings are at the center of concern for sustainable development, and states that they are entitled to a healthy and productive life in harmony with nature. But there are in the Rio Declaration, as there were in Stockholm, several principles of an unambiguous legal character, reinforcing some existing principles and proclaiming new ones. The first category includes Principle 2 concerning the transboundary effects of activities. It repeats Principle 21 of the Stockholm Declaration. Other legal norms are found in Principle 10, affirming the public rights of information, participation, and remedies. Principle 13 calls for the development of liability rules, and Principles 18 and 19 require notifying other states about emergencies and projects that may affect their environment. The formulation of the then emerging principles, including the precautionary principle and polluter pays principle, has been followed by enormous developments in law, including also the general requirement of environmental impact assessment. The precautionary principle has been recognized by the European Court of Human Rights as binding law in Europe under the European Convention on Human Rights. The requirement of the environmental impact assessment is now recognized by the International Court of Justice, also as customary international law. The last group of principles concerns public participation. In addition to Principle 1 or 10 on the rights to information, participation in remedies, Principles 20 to 22 stress the importance of the participation of women, youth, and Indigenous peoples in the protection of the environment and achieving sustainable development. So as I mentioned, the rights set forth in Principle 10 are also accepted now in national law and in international agreements. The principle of common but differentiated responsibilities is recognized in many international agreements. And as I said, the precautionary principle, while debated at Rio, it is now accepted generally and including within the European system as a binding principle of law. So the Rio Declaration established reiterated a number of key principles from the Stockholm Declaration, incorporated others, and elaborated new principles with great practical impact. In the aftermath of Rio, virtually every major environmental convention concerning multilateral cooperation came to include environmental protection as one of the goals of its states. Principle 27 of Rio called on states to cooperate further in the development of the international law on sustainable development. A spike in the number of treaties after the conference demonstrates the impact of the meeting and its concluding texts. Sustainable development became the key organizing concept in all of these developments. So the UN Environment Program continued to reflect these ideas in its Montevideo Program for the development and periodic review of environmental law. So in the aftermath of that, we saw the elaboration of UNDRIP, and then in 2002, the convening of the World Summit on Sustainable Development, which also provided concrete suggestions as to measures to implement the Rio Declaration. The plan mentions the principle of common but differentiated responsibilities and declares that poverty eradication, changing unsustainable patterns of production and consumption, and protecting and managing the natural resource base of economic and social development are overarching objectives of and essential requirements for sustainable development. So at the regional level, the Aarhus Convention was adopted in part as a consequence of Rio Principle 10 and has been very effective in hearing cases that have been brought when states have failed to live up to their obligations. With that, I will stop. Thank you very much.
Muchas gracias, Dinah. Well,
thank you, Dinah. It is totally relevant, this perspective that Professor Shelton has offered us, and it serves as a foundation for the conversation that we're going to have during this panel on classical principles in international environmental law, together with those that are being constructed or drafted in the world we are sharing between the different states. I'd like to mention to our attendees that they can ask the questions on the forum's chat page. That's where the questions can be written, and then we will answer them at the end of the panel.
A continuación, corresponde presentar a la profesora Ángela Amaya. Vamos a leer. Acá mejor.
We will now be hearing Ángela Amaya. She's an attorney from the Externado Colombia University. She's a master in water rights from the Zaragoza University in Spain. She is a doctor of law from the same university. Dr. Amaya is a professor, researcher, and consultant in environmental law and forestry rights for national and international organizations. She's also a member of the International Commission of Environmental Rights. Professor, you have the floor and you have 20 minutes. Good morning. Thank you very much for this invitation to be here today. It is also an honor to form part of this panel with such renowned experts such as Dinah, Shelton, and Peter-Tobias, and the Spanish professor I would like to refer to a principle of environmental law that does not form part of the classical principles that we have seen in this presentation by Professor Dinah Shelton. But it does form part of the principles that are being used nowadays, even if we don't recognize the name at first glance. I'm going to share screen.
Sí, sí, eso. Si lo pusiera es modo
Creo que entonces voy a hacer algo que
presentación. Bueno,
ahí se
Ahí
ve
está
en modo
perfecto.
presentación. Bueno,
ahí está.
entonces yo voy a hablar acerca del principio
So
de no
I'm going to talk about the principle of no regression and how it applies today. Well, this has been mentioned before, but the crisis that we're experiencing may actually imply a reduction in the levels of protection and guarantees, both environmentally speaking, social and economic. This presentation, I started to prepare it in the beginning of the pandemic in March last year, and it's already been a year, and it would seem that the discussion continues to be very much valid. Here's an example that I use a lot, where the economic crises or crisis situations normally bring about less guarantees, less protection. And my doctoral thesis was carried out under Antonio Vipirujo, and Spain was starting to emerge from the crisis, and we were carrying out investigation on wind farms. But basically what happened was that the economic crisis and the social crisis they experienced implied a reduction to the incentives for wind energy. So at the end of these state subventions or benefits, it became expensive again, and it reverted to fossil fuels, and we reinvested in the energy matrix. So there was a greater use of fossil fuels again, with all the known consequences to the environment. And many of the studies in Spain were about how a crisis could imply a reduction in protection levels. How can it actually lead to taking away protections and guarantees? And at the case, the municipalities had to either pay for nurses and professors or subventions for wind energy. So at this point, the situation made them choose. And we started to see how crises begin to show this drop in guarantees. Now, yesterday, I refreshed this presentation and I found these articles from March 2020, both March 2020, and it talked about the positive environmental impact that the coronavirus has left, the planet, the benefits it has enjoyed because of the coronavirus, more water in Venice, wild animals recovering their territories or walking around in our streets. And I didn't find anything this year where this could be so noteworthy. What we saw in the beginning as a breather for the planet and the positive side of this situation, given the pandemic, was actually a moment in time. And then countries began their operations again, and we slowly returned to the original levels. Now, talking about regressions, and I just want to set a few examples before going into the concept. Entrepreneurs, when we have these news, the entrepreneurs in Colombia have found the need to reactivate the economy. They've asked the government to simplify these requirements, to reduce them, to reduce the demand and the paperwork in order to carry out economic activities and to reactivate the economy of the country. And they asked the president to back these express environmental licenses, these were meant to fulfill the requirements and the demands for technical requirements, that they be a little lower. And of course, normally environmental permits take a long time, and that stagnates economic activity. So since we were in a crisis, they basically wrote the government, the corporations wrote the government asking to the government to reactivate the economy and to reduce the processes, or to expedite the environmental authorization processes. Our prosecutor's office also asked to reduce the prior consultations for by virtual media on ethnic peoples. We found a situation where it was not possible to do these in person in the middle of the Amazon. So we began to see how we could guarantee this right to consultations by virtual means. So connectivity in these areas, of course, is not the same. It's not, well, either null or very basic. So it wasn't possible to effectively or efficiently guarantee the protection of their right to participate in those areas. So the government had to make some decisions and said, okay, we're going to authorize virtual consultations. Many citizens organizations also helped, and they actually said that this virtual situation brings about limitation of rights, and communities and the community associations have said that they had not requested that this was just for a specific conversation, but they didn't really want this to be extended to all discussions carried out with the government and between the government and the communities. So this brings about a question: how do we address these situations to avoid this reduction in the levels of environmental protection that had been reached? How do we guarantee the protection of environmental rights in terms of the communities? How do we not reduce the protection standards with these express authorizations, environmental authorizations? And how do we strike a balance between managing a crisis of this scope and how do we still continue to maintain the guarantees? There was another piece in UN News that said no country shall shelter itself in COVID to revert its environmental policies. This is the no regression principle. It has other names in other countries, but it is an obligation, or actually the prohibition of going back on guarantees that have been established and protections that have been established unless they are duly justified. There have to be mechanisms in place for this. So the pandemic coronavirus should not be used as an excuse to reduce these gains. And after this announcement by the UN, several governments said that they would decrease their environmental laws. And in the light of COVID-19, it was said that these actions were irrational and that they were putting in danger the rights of vulnerable and non-vulnerable people. The principle of no regression is a principle that can contribute certain answers. It can offer us answers or strategies to manage this situation that we are experiencing. Where is its origin? It is in the Rio +20 declaration, and it was expressly mentioned as a principle. And again, it was left as fundamental in order not to revert our commitments, to not turn back from them. It is the original doctrine on this It has another origin, which is the principle of progressiveness. The principle of progressiveness that is part of the American Convention of Human Rights is a positive obligation where the states need to progressively increase the guarantee of rights. We all know this. The third generation rights, economic and cultural rights are progressive because they involve an availability of resources. I cannot have perfect potable water availability immediately from one day to the other. It needs to be progressive. But in the same sense, I cannot revert this progressive advance. That is the origin of the explanation. So as I mentioned, this progressiveness and no regression are two sides of the same coin. So no regression is a minimum obligation by the state that is part of the prohibition of adopting measures and policies and consequently of enacting laws that could worsen the situation of the population at the time of the when the international treaty was adopted, but it is not necessarily just about that. Given that the state takes on the obligation to improve the situation of these rights, there is a prohibition to reduce the levels of protection of the laws in force or the rights in force. So the Colombian jurisprudence after Rio +20 already had some of these principles included in the. We have a 2009 sentence that expressed this, and we also have the case of Argentina from 2002. But in Colombia, this division of rights, first generation, second generation, and other kinds of rights, is an academic division. And there is, all rights actually have a phase where the state needs to do something, needs to provide something at a greater or lesser extent. With the first generation rights differ from others. The Constitutional Court says that all rights have their as essential rights. Excuse me, she is speaking at the speed of light or reading at the speed of light. It says that the collective nature of having a healthy environment does not exclude others. The right to a healthy environment may have this essential nature, and we are somehow tied, our hands are somehow tied with this. But the development of the topic has actually shown a way to make this principle operational in reality. In Argentina, it needs to be gradual. That's what they say. The environmental objectives must be achieved gradually by means of internal rules and laws, and also applying the no regression principle. And in France, they have the principle of no regression, through which the protection of the environment is guaranteed by legislative provisions, and of course, taking into account scientific and technical information. And in Peru, I don't know what city it was, on September 6th, it said that the Constitutional Court has recognized the right to the environment in urban planning, and the local governments must respect the minimum standard of green areas in cities. Here we can conclude that from one area to the other, an area turns into an area of protection or of non-protection, of a mixed protection. And it's relevant. On one hand, we see the principle of no regression. We're not mentioning it here. And one of the origins of this principle is the standstill principle, this Belgian principle, which is also mentioned is specifically for the urban areas, green urban areas. These are minimum no return areas. They're not affectable. And this is very strict for planners or for municipalities. This standstill or no return principle says that there are areas where there is a greater protection, and any modification made on these areas will have to be highly justified. The motivation must be qualified. Many more studies must be presented, and so we need to once you have these urban areas, green urban areas, you can't really modify them for just any reason. You need to find very specific justifications. With this example, I will conclude that part. This principle was incorporated into Escazú, the Escazú Agreement. It's Article 3. Principles, each party will be guided by the following principles. There's no definition, but basically you are familiarized with the Global Pact for the Environment. This is a French pact that seeks to establish a series of principles, and the philosophy behind it is that principles, due to soft law principles and non-binding principles, seek to find an agreement for the mandatory nature of this no regression principle. So the parties and subnational entities will abstain from allowing activities or adopting laws that could in any way reduce the level of environmental protection, worldwide environmental protection that is guaranteed by the law in force. So when you read this definition without the asterisk, if you read it to corporations, they are afraid because basically what they feel is there's no freedom for their activities. I'm going to conclude in a moment, but basically, and in conclusion, the principle of no regression has the following premises. One, a reduction of the level of environmental protection that has been reached without a justification or motivation that must be justified. Specifically, there is an obligation from the state that must protect this measure. When I mention the example, this will be much clearer. It does not mean that the standards will become extremely rigid. On the contrary, it seeks to generate flexibility regarding environmental law in order to respond to these new challenges and contexts. The principle of no regression offers general rules to address specific situations. It may be contradictory, but these rules allow us to move in the specific case. And it's not really the same as the prior consultations. There are strategies that allow us to move amongst these and find the best solution for a specific case. It also allows for an analysis that will contribute innovative and different answers to current challenges without reducing constitutional guarantees. For this, we need to go a little behind the theory of the principle, and I created this regression test. It basically helps us analyze the proportionality, how reasonable it is, and it allows for an autonomous judgment. First, we have an analysis of the measure that contains the environmental protection level that has been reached. Basically, I look and see what norm is actually generating that impact. And second, I analyze the actual measure, formal or material, that reduces the level of environmental protection that has been reached. And third, you need to analyze the justification, the end, and the proportionality and the need for it, for this regressive measure. And the inadmissibility or admissibility of this regression measure should not pass the test. In this case, it fully exceeds this regressiveness. They are measures that, although regressive, are admitted by the law. There is a higher motivation, a higher justification that allows for this motivation. So the definition is a restriction to public powers, not only the legislative, but also political operators and judges, to reduce or affect in any significant way the level of environmental protection reached unless it is absolutely and duly justified. This is about an implicit principle that we believe is formulated very subtly, relative, because each specific case has a different judgment, and legally binding because it has its foundations in the principle of no regression, and with constitutional and legal foundations that are increasingly solid and whose limits must be determined on a case-by-case basis. Consequently, the measure will be understood as regressive when it reduces or significantly affects the level of environmental protection reached, unless it is duly justified. This is constantly changing. It is not single provision. I know my time is up. It's 20 minutes. I would like to take 1 or 2 additional minutes to just conclude with the example. This case is noteworthy. It doesn't specifically mention the no regression principle. This is a case from 2012 in Spain, and they wanted to modify the urban planning. So the municipality wanted to change the use of soil to, or the land use, in order to build a library in a green urban area. So basically, they have the discretion to change this use of land. So it wasn't illegal. But what happened was that the Supreme Court, after having made the modification, they sued. There was a lawsuit, and the Supreme Court said, or ruled, that the standstill principle, or the principle of no regression, would protect these green areas. So it required a full analysis of the measure. And again, the green areas, as I said, are no return areas. So what is the first step of the analysis of the principle of no regression? It is the initial measure of the town hall, which requested the change of the use of land to build this library. But how is it authorized? The planner did this legally with adequate argumentation. So they decided to affect a part of the green urban area to build a library. Is it valid? Yes. I am not doing anything illegal. I am building a library, which also represents a legal activity.
So thirdly, there is an impact. And this is when the court said that there had been no indication that the library could only build there. And that is because there had been other aspects in the city, and it's not because it was needed, because it was not proportional, because it was appropriate to build it in this particular park. We go back to the principle of non-regression. We can see how the regulations give us the response. The traditional regulations say, yes, City Hall, you can use the soil as you wish, but the value that society gives to its park area means that even though the regulations are valid and the actions are valid, then these principles begin to give different answers in concrete cases. Now, this transformation of law through the principle of non-regression is a principle or an example of how this principle has enabled us to find different innovative solutions to the crises that we are experiencing today. For example, in the case of the impact on Indigenous rights, if we continue to look at this in the same silo that we've always used, then the principles will not be useful. But if we begin to use other disciplines, such as design and legal innovation, the use of technology in keeping with constitutional rights, then we will be able to transform the law and legality to continue with this evolution of the principles of environmental law so that they in fact can help us solve the crises that we are experiencing on our planet today. I'm sorry I ran 4 minutes over. Thank you very much. I will stop sharing my screen. And on that note, again, I will conclude. Thank you, Ángela. That is a very fast-paced but clear presentation that enables the judges to look at other options. As you quite rightly said, there is perhaps sometimes an erroneous belief that the principles support the legal structure, and people fail to see that they can serve as an escape valve when there are legal constraints that are forcing a situation that is patently unjust. So this reasoning that you mentioned, this reasonability criteria that you've referred to, and the test of proportionality, need, and so forth, if these can be attained in the specific case for the administration, for a judge, being able to do an objective analysis of pertinence is important. And it is excellent work. So congratulations, Ángela, for this outstanding presentation and tremendous food for thought. Let me now turn to our next speaker. We will now hear from, well, let's see if Susana is here. There she is. Now I see her. Professor Susana Borras. Am I pronouncing that correctly? Borras? Yes, with the accent on the A. She is an attorney at law, master in environmental law, PhD in European law, and has also been awarded outstanding researcher awards by her university on mitigation, local government, and environmental law, the Center of Environmental Law at Universidad Rovira y Virgili in Barcelona. You have the floor, 20 minutes, Professor. Thank you very much. I would like to share my screen. I trust that you will be able to see that. If you could perhaps put it in presentation mode. Perfect. Very well. Good morning or good afternoon. I am pleased to be able to participate in this 4th International Forum on Environmental Law. It is a privilege and an honor, and I am thrilled to be able to join the other speakers on this panel for such timely thoughts. My contribution here will be less legal or practical in nature and more theoretical in nature. Take a moment to think, to reflect is also important, and it is a good time for us to do this at this juncture, I believe. I would like to thank, of course, Cristian del Piano for the invitation and the Second Environmental Court as well for this opportunity to be remotely in Chile. I wanted to begin by recognizing that there is an illness on the planet today, not just the pandemic, but the current crisis, which is multi-dimensional. Climate change, environmental, social, energy, poverty, economic crisis, crisis of law. All of these are symptoms of a very severe illness that affects the planet, but that stems from our system. In fact, we shouldn't be talking about the pandemic, but the most important, or a better word would be syndemic. This is, as we've seen, as Paul Crutzen, Professor Crutzen, Nobel laureate in chemistry, recognized that for the first time in history of the planet, we have seen how human beings have been able to modify how Earth operates. Again, a few million years ago, human beings were just a moment, just a blip on our screen. And yet, as human beings, we represent 0.01% of the life present on the planet, and yet our impact is extraordinarily disproportional. And despite our significance on the globe, we've altered it significantly. Now, of course, not all of us have done so to the same extent, and not all have had the same impact. At this time where we're seeing this eco-social collapse, we can see how this has become much more severe. It is not in vain that Bana Shiva has talked about how we are experiencing these different symptoms of this illness, the extinction of biodiversity, among other symptoms. We're seeing what we called the seventh elimination. According to the IPBES ecosystem assessment, we can see over 1 million species are in dangers, including, and we've seen a very large number that have already become extinct. The pandemic, of course, has been extremely harmful, but it's also shown us the eco-social crisis, and that is giving us an expansive system as well that involves a dynamic that reduces the space available to living beings, and we've sought to eliminate, nonetheless, a number of biological entities, and we've seen efforts to combat microbes for many years, and this clearly has had an impact on life on our planet. We are now at the verge of the planetary boundaries. Professors Rockstrom and Richardson in 2009 discussed these planetary boundaries and said which ones we simply cannot cross. And if we did so, we would end up in a type of uncertainty in which our life as humans would be compromised. Recognizing these boundaries also helps us to better understand that deaths and viruses are not happenstance. The pandemic, of course, has been the result of this so-called civilizing effort, and the research by Rockstrom and others, again in 2009, told us that we had planetary boundaries, which we identified in loss of biodiversity and nitrogen and climate change were already beyond the uncertainty threshold and severe risk. And in 2015, a new version of this study added two more. That's the phosphorus cycle and the change in the use of soil. That is to say that we have 5 of the 9 boundaries that are at the dangerous level to, again, endangering the survival of the human race. Now, these scientific research and these boundaries, as you know, of course, are not novel. It's been some 50 years now since in 1962, a publication was made at MIT that referred to the danger of overcoming or surpassing the biophysical capacities of the planet. And yet we did not see environmental policies and so forth to contain this growth. And we, despite certain efforts, we are nonetheless on the brink of collapse. In fact, we've also, in this healthcare crisis, have tended to ignore the emerging and the present climate emergency. We have greenhouse gases that are, of course, responsible for climate change that are now being ignored, despite the fact that we have reduced our growth and our emissions during the pandemic. We are nonetheless suffering. It has not reduced climate change at all. Now, if we look at the special report from 2019, with regard to seeking to restrict climate change and global warming to 1.5 degrees centigrade, we've seen that there is a scenario that if we do not take appropriate measures to grapple with this other crisis, one of global warming, in addition to the health crisis, we, by 2050, again, according to the IPCC specialists, we will see global warming at about 4.5 degrees centigrade. Therefore, the lack of effective progress is tremendous, along with the loss of biodiversity. These are undoubtedly the biggest challenges that we are confronting today to ensure life, not just human life, but life on the planet as we know it. The Worldwide Fund and others in Australia have made it clear how this loss of biodiversity is generating very profound changes in ecosystems that compromise life of ecosystems and of millions of human beings. Well, what does this have to do with the principles of environmental law? I would like to thank Professor Shelton for all of that, the historic overview that she has given us, because it is very clear how these principles have evolved, despite the fact that these tools are available. It is clear that we've nonetheless been unable to prevent the collapse of ecosystems. The principles of environmental law are important and are key to allowing for respect and have predated regulations. Therefore, these principles are the primary tools that enable us to move toward better tools to grapple with the current emergencies. The principles reflect consensus built by the international community, despite the fact that the international community and states have tremendous environmental, social, economic, and political disparities. Nonetheless, the principles of international or environmental law have nonetheless played a key role that goes beyond the principles enshrined in other fields of law. And Professor Shelton has noted this clearly. The Declaration of Rio, the principles emanating out of Stockholm, and so forth, suggest that their broader acceptance, their recognition in domestic law, and the fact that they have been enshrined in international treaties have led us to understand that many of them autonomously have come to supplement Harborough principles, and some of them are now considered to be jus cogens. So they are multifunctional, heuristic, and so forth. But in any case, as I said previously, despite these advantages in the scientific and the legal perspective within the context of environmental law, there are certain limitations. Again, and that is that collapse has not been avoided. Now, one of the shortcomings is that these principles are dependent on substantive law. Another shortcoming into these principles is that they are primarily anthropocentric, where people are at the heart of sustainable development, and life is limited in its recognition by law to human life. But the recognition is that we are living in the era of the consequences of all of these forms of collapse. We are eco-dependent beings, and we can see that this eco-social collapse, the era of consequences, as Granton has said, of living in the Anthropocene, means that we must take, of course, urgent action. It also requires that we understand that we must create new ways of interacting between and among the forms of life on the planet. The relationship between human beings and nature historically has been one of use and abuse, and environmental law and the principles of environmental law have been unable to avoid that. Therefore, we need a new concilium to protect life on planet Earth, not just human life. Therefore, there is a needed response. It's just like we saw in the 1970s, there's the ecologic movement in the 1970s that emerged in an effort to build a system that is capable of responding to these environmental challenges. Just as that movement emerged, we need an opportunity or way of going and looking at the traditional law, that anthropocentric approach, to a vision that will enable us to focus on life. And therefore, as a social process, we all need to engage in this process. The principles, despite the limitations, I believe are the necessary means, the necessary vehicle that will enable us to transit toward an eco-civilization that will move from the Anthropocene to our ecocene, based on what Leonardo Leboeuf has said. The use of the system has led to a hegemonic approach, not only to nature, but also to human beings. And not only just of human beings, but also human populations that are most impoverished and most disenfranchised as a result of the hegemonic powers that have led to a dominant and domineering approach to nature. We therefore need decolonialization, not just of politics, but also the environment. The law from the anthropocentric perspective is not sufficient to protect human life or natural life, and particularly the life that really needs additional protection. Therefore, we need a moment of inflection, of thought, to be able to reflect on these global issues and how these problems are looking at the biosphere, and which is very much alarming in terms of change. And all of these problems, therefore, are not just pandemic, but syndemic and systemic, that must be analyzed in an interconnected and interdependent fashion.
Therefore, this should take us to making environmental law more ecological. And we should call it the principle of ecocene, the ecocene, not the Anthropocene. And it must be done in dubio pro natura with the no regression principle. It must be based on two premises, two pillars. One is the affirmation that all living beings have the right to enjoy their development as such and to live their lives. And the second pillar is that every life form is interdependent and needs physical support. So this is the fundamental right that we find in the nature chart, where life is the main support of this transit into the ecocene principle. What are the principles of the ecocene in this legal order that must make environmental law more ecological? Some are found in the International Charter of the Environment from 1982. Others are indirectly found in the Rio Declaration. Others were finally developed by the declaration of the ICM that was agreed at the Global Conference in Rio de Janeiro in 2006. And some have been the result or have had a greater impact at an international level, but also in internal legislative laws, as Professor Amaya mentioned, the principle of no regression, the principle of progression, and the protection of the environment, as well as the indubio, the intergenerational protection, the indubio pro natura, which means that all processes need to be resolved in a way that will favor the conservation of the environment, offering preference to the alternatives that are less deleterious to the environment. So it is the prohibition of any action that could imply a reduction of the protection of the environment or access to environmental justice. The principle of progression, which together with the no regression principle are both found in the Escazú Agreement. But this one is also included in the Paris Agreement. It's necessary that the obligation to review and periodically improve these laws and regulations in order to restore and improve the environment, and the intergenerational principle also linked to the interspecies. It is this intergenerational and interspecies legislation that is going to be in favor of these lives. All these principles materialize this right based on ecological means that do not want to replace the traditional environmental means, but to reinforce them, to facilitate the transition of this exclusive anthropocentric transition, and to include a less restrictive perception of the concept of rights. The idea is to expand this concept of rights to include other non-human species. That is what we mean by ecological justice in the three dimensions: spatial, the regional, national, and planetary level, the intergenerational and intragenerational dimension, and the biocentric dimension, which includes the intra and interspecies. That is why I chose these 5 principles of all the others that have been mentioned and developed as of Rio 92 and Rio +20, because I believe they stress this vision, this change towards an ecological or environmental justice that guarantees the dignity and integrity of all forms of life and the survival of human species. So it is a planetary effort based on this ecological justice, and the main axis must be the principle of ecological sustainability and not just sustainable development and resilience in order to achieve the protection and reestablishment of the integrity of all ecosystems, as well as maintaining and continuing with the resilience of all these systems in order not to exceed these planetary limits that we were referring to. So it is a matter of adaptation to this eco-social crisis. It's resilience and advancement of what we already have in our current reality, but it's also about responsibility. And these principles have not only been developed as part of this global impact for the environment, but also the doctrine. This path of this development of these principles has already begun. And in traditional law that has been developed, we've seen this with this conciliation of biocentrism, which was presented before by Ecuador, Bolivia, other Latin American countries, which allow transforming classic environmental law by lightening up this anthropocentric perspective and including the new elements of biocentrism. Again, we do not wish to replace one with the other. We do not want to quit or renounce what has been done these past years. We want to have a progression of life so that it can be guaranteed. On the other hand, if we were to say that environmental law with this anthropocentric perspective could have been defended by means of the application of the principle of a right and of future generations, well, it's not like that now. the way things are today with the eco-social crisis, we cannot guarantee the right of new generations to enjoy a healthy environment. So the anthropocentric perspective of a human right cannot really be projected into the future. So we need our elements or different elements that will allow us to guarantee this systemic perspective in order to guarantee the anthropocentric perspective. So we have these political and economic things that enable the effort and bring environmental law together with other branches of law, commercial, civil, etc. So all these tools that have been used for other players, why perhaps we should use it to recognize rights that are broader than what we have conceived anthropogenically in order to guarantee our own human rights. I would like to conclude by stressing the principle that represents, that I feel is most important. And the principle of no regression and the principle of progression and of this commitment to nature and the need to respect this legacy for coming generations, future generations. That is the indubio pro natura principle. And this principle has been broadly presented in jurisprudence in Latin American countries, Venezuela, Dominican Republic, Costa Rica, Ecuador, and even Chile, and directly has done it by recognizing indubio pro ambiente. And it includes this need, this principle that began linked to other precautionary measures in Venezuela, Costa Rica, Dominican Republic, has progressively evolved to the point it has a substantive character, and Costa Rica it's used to interpret the conflict, any conflicts that may arise, and those laws that are favorable to nature. So this is a principle that should be applied in jurisprudential seats, and as in the case of Ecuador or Costa Rica, subsequently, it would have expanded as a hermeneutical principle for conflict resolution between environmental laws, but also as a principle that should inspire the need to bring it to the political and administrative realm. It's not easy. It's been subject to a lot of issues, many conflicts, but the situation shows an increasing need to follow this line of improving environmental law, of anthropocentrism, of having an environmental law that is more ecological, that better responds to environmental justice, but also ecological justice. It must also answer the need to include human rights should there be an eco-social collapse. It's important to include this regressive situation together with environmental protection. And with this perception of leaving a legacy to future generations. If we continue the way we are going, the earth will degenerate. Eventually it would recover, but the human species as we know it will probably be extinguished. I will conclude with this third point, which is that the relevance of the indubio pro natura principle, as in the case of the other principles that we've mentioned, are ex novo, and they should be applied with this judicial principles that we have seen that are being included in Latin America. They are hermeneutical principles that would also have to be applied to decision making. So with this last reflection, I will conclude my presentation. Once again, thank you very much for the invitation to participate in this 4th International Forum on Environmental Law. Thank you.
Thank you very much, Susana. Very interesting and thought-provoking presentation for those countries that are moving through a process of rewriting our constitutions. What you have suggested is certainly, again, food for thought in that process. And noting how, particularly that the principles have not led to, or not stood as an impediment to deteriorating environmental conditions. And perhaps we can think about more intensive application of them in the future. That leads us to a question for the panel that was posed in the previous session about the future of the panel. Excuse me, the future of the planet. The interpreter apologizes for the drilling noise in the background. Unfortunately, there is nothing she can do about it. Let me now turn to Peter-Tobias Stoll. You will have the floor in just a moment, but I believe there's a tall task before you, as the presentations that we have heard have been tremendous and extraordinary. So no pressure, my dear friend Peter. Professor Stoll is a professor of law. He is the director of the Institute for International Law and European Law. His areas of research are EU law and interfaces between economic law, trade, investment and trade, environmental protection, and consumers. He's also participated in a number of negotiations at the international level on behalf of the German government, including the Ministry of Foreign Affairs, Ministry of Agriculture, and the Ministry of the Environment. Without further ado, Professor Stoll, you have the floor. You have 20 minutes. Thank you.
Chair Mauricio, thank you very much for this and for the kind introduction. Members of the panel, ladies and gentlemen, thanks to the generosity of the president of this court, which is Christian Del Piano, a good colleague and friend, some years ago I had the opportunity to participate in the opening ceremony of the first environmental court in Antofagasta. I consider the establishment of environmental courts an important achievement, and I hope my country will follow suit sometime. I'm not very optimistic about that. It is even more impressive to see that this court also engages as a forum for discussion on environmental law, and I'm really fascinated from this richness of thought in principles, in constitutional developments that I had the honor to part in. Such reflection, I think, is necessary in a young and quickly developing field of law. Thank you very much for the honor to be invited to participate in this endeavor. Today, I will try to explain to you the EU's Green Deal that might be far away from Santiago, but I do so nevertheless for two reasons. First of all, some small information might be welcome, but secondly, I would like to use that development as a starting point to reflect on the principle of sustainable development and what we as lawyers could do about it. And with this, I try to share my screen. Hope it works. And I added a subtitle which is Exploring Potentials Task for Legal Reflection, in order to tell you that this is a work in progress, and it's actually required to me because I have a Jean Monnet chair, especially on sustainable development, and I work in this area. And I would like to share some of my observations and questions with you. I consider the principle of sustainable development to be one of the most impressive innovations in international relations and law. Let me say this, and I'm happy that Dinah referred to us and explained us so ably the developments and the content of the Rio Declaration. It is not only that it married, in a way, environmental and developmental policies. It is also so because this idea of sustainable development had implications for international, for regional and national levels. It has had also, of course, a very strong political outcome. So basically the SDGs, which in a way concretized and translated sustainable development in objectives, in goals that you could measure, and that was certainly another very big improvement. The principle of sustainable development also had a very huge legal impact. It has not only been incorporated into numerous international agreements and national and regional legislation, but it also has been frequently referred to by courts. And Dina has already explained that in some regard, it could also be considered to be customary international law right now. And I should say, in a way, we as international, regional, or national environmental lawyers have been very much charged in recent times with bringing this about, in trying to help to translate the principle into legislation or international agreements, and to help to bring it to bearing in courts and tribunals. And this has been a great effort and a great achievement. But I wonder a little bit whether we could go more far in a way in unfolding the principle. Now that we have achieved kind of legal acknowledgement of the principle, I wonder if we as environmental lawyers could not do much more in fully bringing it to its potential. And I will tell you in a minute why this is very much important. I think it is very much important when I look to what I know a little bit more about, which is this huge project going on in the European Union, which has the name EU Green Deal. As you know, this project has been set up by the new EU Commission under Commissioner Ursula von der Leyen, and she really made, in a way, kind of a political program which would cover, in a way, all EU policies, and which basically is not only understood to be green in the sense of environmental protection, but it's also deeply informed in a way by our ideas of sustainable development, and particularly by the Sustainable Development Goals. And it explicitly refers to the Sustainable Development Goals in stating that the Green Deal is considered to be the EU's implementation of those SDGs. And if you read the basic document, there's a quotation saying that the Green Deal is a set of deeply transformative policies. And really, in Brussels and in the whole EU, there are very high expectations because, can you hear me? Hoppala. Okay.
The interpreter can hear you.
Okay. Because I got a sign that I couldn't be heard. Okay, thank you so much. Can you hear me, anybody?
Yes, we can hear
Okay,
you.
thank you. I'm very sorry for that. Just in brief, to explain to you the EU Green Deal, and I will put a graph from the EU Commission on my next slide. Basically, it covers a number of well-known environmental policies of the European Union. But it's not only that. It's not only that the goals are very ambitious. It is also a very close kind of a integration between environmental policies and the economy. And I briefly refer only to the sector of energy, mobility, and sustainable finance, which I think is a very good idea. But what is rather new about it, because so far the European Union was basically considering sustainable development something for environmental policies and for international relations and for international development cooperation. But now the European Union in a way acknowledges that really implementing sustainable development would also need a kind of a social pillar. So this social and societal dimension of sustainable development is in a way well addressed, and there is often mentioning of the word "no one left behind." And you know this from kind of US and United Nations papers and documents, this word for which is basically about social justice and social rights. So, for instance, it envisages a just transition mechanism, which is basically funding for those parts of industry, but also of society at large in the context of the implementation of the whole Green Deal. And there's also something called the Sustainable Europe Investment Plan. Altogether, there's a very nice graph in this basic paper, which explains to you the various issue areas of this Green Deal. And so it includes a lot about climate change, energy policy, circular economy, building and renovation. There is a shift to sustainable and smart mobility. The farm to fork part of the paper is very much about reforming EU agricultural policies. There is, of course, something on ecosystems and biodiversity, and something on zero pollution for toxic-free environment. Altogether, it has this very funny kind of understanding that the European Union would be a global leader. I think that is rather selfish if we look to other regions. For instance, if we look to your regions with the many important and fascinating developments, then I would like it to have a smaller coin, but nevertheless. Also, it's about research and innovation, so it's good for European universities. In a way, I'm joking. But it's rather interesting because at the same time, an agency of the European Union, which is Eurostat, which is the statistical agency for the European Union, tried to develop kind of a mechanism to calculate the progress of the European Union in the area of the Sustainable Development Goals. And you can see here, I'm sorry if you can't really read the graph in all details, but you can see that there's actually a development in Brussels to make visual the kind of progress that the European Union is doing in terms of the SDGs. And you see, we have, we have very much progress in the area of peace and justice, but we have very poor progress in non-discrimination. And you see all the different kind of environmental and other issues are in between somehow. But I'm not after the details of this graph, but I would like to explain to you that if we look at this whole development of the Green Deal altogether, we would find that it is basically a governmental program, and that has quite some tradition in the European Union. And of course, the Green Deal documents as such would not have any kind of a direct legal effect. And I'm sorry that Geert Winter is not in this session, because he was lately discussing the question whether there could be an indirect legal effect of kind of governmental programs and decisions. But nevertheless, it is, of course, a master plan for legislation to come. There are lots of legislative projects in the Green Deal, so we can watch out what will come later. But my point is that there is not much kind of a legal context. So sustainable development in the lens of the Green Deal is understood as kind of a huge technocratic, bureaucratic endeavor, which is certainly in a way laudable and which is also quite impressive. But the question remains, isn't there something to do for the lawyers? You could even believe that either sustainable development is fully implemented when with the Green Deal, if you read all the prosa in the basic documents, or you could believe that sustainable development turned into something which is in the hands of governments and is treated by their normal kind of technocrat work, which is certainly laudable and important, but of course is not the whole story. And when I came to this point in looking at the Green Deal, I thought, what should lawyers do about it? We have this wonderful principle of sustainable development, which goes back to the Rio Declaration, and as Dinah rightly explained, basically has been mentioned the first time in the Brundtland report. And we are very happy to see the Sustainable Development Principle to be, in a way, incorporated in hard international, regional, and national law. But I think that is not the end of the story. But what we possibly have to do is something what our colleagues from human rights always call the mainstreaming. That would say it's not enough to establish normativity for a principle or for a rather generally framed right, but you would also need, in a way, to contextualize it in the context of other legal provisions and mechanisms at hand. And that is, I call it contextualization, but I'm also happy to use the word mainstreaming. But that is certainly something which is lacking with this Green Deal project. And if you consider all those provisions which we have in EU law, which are not cited in this papers on the Green Deal, there's already kind of enough starting points for doing so. We have, for instance, the idea that sustainable development is a basic principle not only for the economic policy of the European Union, but certainly it's also the basic principle for environmental policies of the European Union. And even more, in our, as you might know, the European Union got, with the Lisbon Agreement, got something like a Bill of Rights. And there we have in Article 37, which actually states a high level of environmental protection and the improvement of the quality of the environment must be integrated into the policies of the Union and ensured in accordance with the principle of sustainable development. That is really fascinating because the Charter of Fundamental Rights of the European Union is considered to be a Bill of Rights, basically. Nevertheless, and interestingly, this provision is situated in Title 4 of that charter, and which carries the title Solidarity, which is already pointing to the so far forgotten social element of sustainable development in EU policies. But of course, on the other hand, it's not an individual right. It's something like a principle. Article 37 would not qualify to rely on it in courts. So that is the downside of Article 37. So why am I trying to find kind of a legal contextualization to a wonderful governmental program? Because I basically think that even those huge bureaucratic processes would need, in a way, that somebody puts the legitimacy question, which is an inherent legal question. We need lawyers and we need the law to attribute rights and responsibilities, because this is a simple political program. We need, I think, the law to give orientation and to achieve coherence. And some of those functions, I think that we could do more as legal academics and practicing lawyers and, of course, judges, to more unfold and to reach the full potential of principles like the principle of sustainable development. As I stated, so far, judges, lawyers, and legal academics have already achieved something. We have, in a way, manifested the legal validity of the principle of sustainable development, as I explained. And we have been busy with developing some more important procedural dimensions, which is transparency, the idea that we should have impact assessments. And also we have been quite busy with giving a voice to individuals and to the civil society or to groups. We had a number of legal developments, both nationally, at a regional level and internationally, in view of access to justice, in view of the involvement of civil society, and which, as you all know, basically resulted even in this fascinating area of climate action and environmental litigation. But what I think is so far left on the table and could be good PhD projects, so to speak, is first of all, and Dinah's talk reminded me to that we try to see all the Rio principles in context. So far we are picking out, be it sustainable development, be it the principle 15, which is precaution, or be it other principles. But especially the presentation of Dinah reminded me to saying that there's much more in the Rio Declaration, and that we should work on the question whether all those principles, how they fit together, and whether perhaps the sustainable development principles is something like the umbrella for all of that, would help us to develop a more nuanced and more contextualized picture of all the interrelationship between the principles, which could help us in cases. Could it be in court cases, in legislation, or whatever you have. The second is, and where Latin America is, or Pan America, so to speak, is of course a forerunner, is to see the contexts between sustainable development goals and human or fundamental rights, and vice versa. The kind of bringing into context sustainable development goals with fundamental or human rights will help to add legitimacy to the Sustainable Development Goals and make them in a way also more tenable to courts and others who apply the law, if we have an understanding how the Sustainable Development Goals would be linked to certain individual rights, or the other way around, if we do interpret human rights or fundamental rights, then that we take recourse also to the Sustainable Development Goals to give us an orientation about the interpretation. So I think there could be much more be done in these two areas. But then on top of it, and then that is why I was fascinated by all the presentations in the panel on developing further other principles, was to see whether we could use the Sustainable Development Principle also to develop measures or criteria for coherence, for instance, of government policies. So for instance, in institutional and procedural dimensions, the question could be, is sustainable development from a legal point of view adequately reflected in the institutional setup? And if you look from this side, you would find, for instance, that in the European Union, sustainable development was for a long time separated between different directors generals of the Commission, and that until now we do not have a committee for sustainable development in the European Parliament. We have rather industry, social affairs, environmental affairs, trade affairs, and something like this. And of course, the European Parliament is very busy in giving its views on sustainability development, but wouldn't the principle perhaps require us to have one institutional core where all those facets and dimensions of sustainable development come together? And then secondly, I think we could do a good job in bringing coherence to the question whether governmental policies and legislation is based on proper assessment, discussed with proper participation, and has a review mechanism, because we understand that environmental affairs are developing all the time. And also, and thank you for others to point to those two principles, I would say that we could also do something in bringing coherence in applying the principle of proportionality, more enlightening than we do it before, and also perhaps the principle of non-discrimination, because funnily enough, if you read the constitutional law of the European Union, there's more than one. Indeed, there are many provisions which call for the coherence of European Union policies, and would be interesting to use this in context with the principle of sustainable development. I'm very sorry that I couldn't give you any answers, but I thought perhaps it's nice to give you some questions and some ideas to continue working for sustainable development. And thank you very much for your attention. Thank you.
Muchas gracias a ti, Peter.
Thank you very much, Peter, for that very interesting presentation.
Muy desafiante de cara a los problemas, ¿cierto? A los conflictos socioambientales.
And particularly these references to the conflicts and the issues that we are grappling with and that you're looking at in the EU. Panelists, given the time, since we have run rather late, we will not have an opportunity for a Q&A session, despite the high quality questions that were posed by the audience. Therefore, all I can do at this juncture is thank you for your remarks and for your participation, and therefore I will give the floor back to our host, to Magdalena, as our moderator, our leader. Thank you very much, Mauricio. We again appreciate the participation of all. We will take a break. We are going to come back punctually at 3:20 p.m. Chile time to continue with our next and sixth and final session on judicial experiences.